evening, all. I'm Kaveri S, second year LLM student, Government Law College, Thiruvananthapuram. Today, I'm dealing with the topic Discharge of Contract. In India, the law relating to contracts is contained in the Indian Contract Act 1872. The Indian Contract Act 1872 deals with the general principles of law of contract and some special contracts. The Indian Contract Act 1872 is not an exhaustive enactment. It deals only with the general principles of law of contract and some special contracts. The preamble itself shows that it is to define and to amend certain parts of the law relating to contracts. The contract relating to partnership, sale of goods, negotiable instruments, etc., are not dealt with by the Indian Contract Act 1872. There are separate enactments to deal with them. So, a contract is an agreement enforceable by law. A contract creates rights and obligations. A contract is said to be discharged when the rights and liabilities created by it come to an end. A contract may be terminated or discharged by different ways. So, my topic is discharge of contract, and I will explain it in details the different ways in which a contract is terminated or discharged. So, a contract may be discharged or terminated by the performance under sections 37 and 38 of the Indian Contract Act 1872 and by agreement or consent under section 62 or 63 and by impossibility under section 56 or by lapse of time, by operation of law or by breach of contract under section 39. The first one is the discharge of contract by performance. Performance of contract takes place when the parties to a contract fulfill their respective obligations. Performance may be actual or attempted. Actual performance occurs when a party has done what he undertook to do. A contract. Hello, am I audible?
Yes, continue.
Okay. Performance may be actual or attempted. Actual performance occurs when a party has done what he undertook to do. A contract need not be actually performed. The party who is bound to perform his obligation under the contract may make an offer to the other party to perform his obligation. An offer to perform obligation is called attempted performance or tender of performance. A party who has entered into a contract to deliver goods or to pay money to another is deemed to have performed it if he has offered the goods or money to the party to whom the delivery or payments was to be made. It falls short of actual performance solely because of the wrongful refusal by the promisor. The effect of the tender is to discharge the promisor from responsibility for non-performance. At the same time, it preserves his rights under the contract intact. In case the promisor dies before the performance of a contract, his promises are binding to his representatives, unless a contrary intention appears from the contract. In the case of contracts involving special personal qualification of the promisor himself must perform the contract. For example, X promises to paint a wall for Y on a certain day at certain price. X dies before the day. The contract cannot be enforced either by the representatives of X or by Y. Then the next is discharge by agreement or consent. A contractual obligation is created by agreement and it can be destroyed by consent of the parties. The rule of law in this regard is based on the maxim "Iudem modo quo constituter, iudem modo destructor." It means that a thing may be destroyed in the same manner in which it is constituted. The discharge by consent may be express or implied. Section 62 and 63 of the Indian Contract Act deals with the provisions of discharge by mutual agreement. Section 62 provides that the parties to a contract agree to substitute a new contract for it or to rescind or alter it. The original contract need not be performed. Section 63 embodies that every promisee may dispense with or remit or wholly or in part the performance of the promise made to him, or may extend the time of such performance, or may accept instead of with any satisfaction which he thinks fit. So the following are the various modes of discharge of a contract by mutual agreement. The first one is novation. If the parties to an existing contract agree to substitute a new contract in the place of an existing contract, the situation is known as novation. Novation is the supersession of one contract by a new contract. The new contract may be between the same parties or between the existing parties and a third party. For example, X owes Y rupees 5,000. He enters into an agreement with Y and gives Y a mortgage of his estate for rupees 2,000 in place of a debt of rupees 5,000. This is a new contract which extinguishes the old one. Novation should takes place before the breach of contract occurs. If for any reason the new contract proves to be invalid, the old contract which it superseded stands revived. The next one is rescission. Rescission is the cancellation of the agreement. If the parties to an agreement agree to rescind it, the original agreement need not be performed. For example, X promised to deliver certain goods to Y on a certain date. Before the date of performance, X and Y mutually agree that the contract need not be performed. The contract is said to be rescinded. The third one is alteration. Alteration of a contract occurs when the terms of the contract are varied by mutual consent of the parties to a contract. For example, X enters into a contract with Y for the supply of 299 bales of cotton. By the 10th of the next month, X and Y subsequently agrees that 199 bales of cotton is to be supplied on 10th of the next month and the balance of on 15th of the next month. This is an example for alteration of the contract. Then the next one is remission. Remission of a contract indicates the acceptance of a lesser sum than the agreed amount and discharging the debtor from further liability. For example, X owed rupees 4,000 to Y. X paid rupees 3,000 to Y and Y accepted it in full satisfaction. In this case, X is discharged from his liability of rupees 4,000. The next one is waiver. Waiver is the intentional relinquishment or abandonment of a claim or right which a person is entitled to. Neither an agreement nor a consideration is required to constitute a waiver. For example, X promises to paint a picture for Y. Y later on forbid him to do so. X is no longer bound to perform the promise. The next one is merger. Merger occurs when a superior right and an inferior right concur and meet in one and the same person. The inferior right vanishes into the superior right. For example, A holds a property under a lease. He later buys the property. His rights and his right as a lessee merges into his right as an owner. The next one is accord and satisfaction. Accord and satisfaction is the acceptance of any other satisfaction than the performance originally agreed. In other words, accord is the agreement by which the obligation is discharged, and satisfaction is the consideration which makes the agreement operate. For example, A owes B rupees 2,000. B agrees to accept rupees 1,000 in full satisfaction. The agreement to pay rupees 1,000 is an accord and the actual payment is a satisfaction. Here, a case should be remembered, that is penal's case. In this case, the defendant owed penal 30 pounds. He paid 5,000, which penal accepted as full satisfaction of the debt. Subsequently, penal brought an action for recovering the balance of 8 pounds. It was held that part payment of a debt cannot operate as satisfaction of the liability for the entire debt. The agreement of penal to remit the balance of 8 pounds was unsupported by the consideration and was invalid. The suit was accordingly decreed. The rule in penal case is not applicable in India. So these are the modes. The next one is discharge by impossibility of performance or frustration of contract. Frustration means the discharge of a contractual obligation which is impossible of performance by external causes beyond the contemplation of the parties. The effect of frustration is that the contract becomes void. Section 56 deals with frustration of contract. For example, X and Y contract to marry each other. Before the time fixed for the marriage, X goes mad. The contract become void. Discharge by impossibility of performance is based on the maxim lex non cogit ad impossibilia. That is, what is impossible does not create an obligation. Impossibility of performance of a contract may appear on the face of it, or may exist unknown to the parties at the time of making the contract, or may arise after the contract is made. In the first case, the contract is ab initio void. In the second case, the contract is void, and it is known as the doctrine of supervening impossibility or subsequent illegality. The basis of the doctrine of frustration is rested upon an implied term of the contract. In England, the doctrine of frustration is a parallel concept of supervening impossibility under Section 56 of the Indian Contract Act. This doctrine is invoked in two types of cases. If a supervening event makes the performance of the obligation impossible, or if there is a fundamental change in the situation, even though the performance may not have become physically impossible. A contract is discharged by supervening impossibility in the following circumstances. By destruction of a subject matter, death or disablement of parties, contract becomes subsequently illegal, declaration of war, non-existence of a particular state of things. In detail, the first one is destruction of subject matter of the contract. When the subject matter of the contract is destroyed without any fault of the parties, the contract is said to be discharged. In the case of Taylor versus Caldwell, the defendant agreed to let out a music hall to the plaintiff on specified dates for the purpose of entertainment. The hall was destroyed by fire prior to these dates. The plaintiff sued the defendant for damages for breach of contract. The court held the contract has become void and the defendant was not liable to pay damages. The next one is subsequent illegality. Whereby subsequent to the formation of contract, the law changes and thereby the performance of a contract is forbidden. The parties are exonerated from liability to perform it. In the case of Bailey versus D. Crespini, D. Crespini leased some land to Bailey and agreed to erect some ornamental buildings on the adjoining land. A railway company under the statutory powers acquired this adjoining land and built a railway station on it. In this case, the court held D. Crespini excused from performance of the contract. Then, declaration of war. A contract entered into with an alien enemy during the war is void ab initio. A contract entered into prior to the outbreak of war is suspended during the war and may be revived after the war. Then, non-existence of a particular state of thing. If there is any change in the state of the things which is performed on the basis of the contract, or if the state of things which ought to have occurred does not occur, the contract is discharged. So, this is the discharge by impossibility of performance, and next more way to discharge a contract is discharge by breach of contract, where the promisor neither performs his contract nor does his tender performance, or where the performance is defective, there is breach of contract. There's a breach of contract. It may be actual breach of contract or anticipatory breach of contract. Actual breach of contract means the actual breach may occur either at the time the performance is due or when actually performing the contract. The anticipatory breach of contract indicates a breach before the performance is due. This may occur either by the promisor doing an act which makes the performance of his promise impossible, or by the promisor in some other way showing his intention not to perform it. If a party to a contract refuses to perform his part of the contract prior to the date of performance, the promisee has certain rights. He can either treat the contract as discharged so that he is exonerated of the performance of his part of the promise, or immediately take a legal action for breach of contract, or wait till the due date of the performance. So, the remedies for breach of contract, the process of enforcing rights is known as the remedies for breach of contract. Where there is a breach of contract, the injured party has one or more of the following rights: that is, rescission of the contract, suit for damages, suit upon quantum merit, a suit for specific performance of the contract, suit for injunction. So, these are the remedies. Remedies for breach of contract. So, to sum up, a contract is, to sum up the discharge. To sum up my topic, the ways for termination or discharge of a contract are by the performance under section 37 and 38, or by agreement or consent, mutual consent under section 62 and 63, or by impossibility under section 56, or lapse of time, or operational flaw, or breach of contract under section 39. I have also included some questions. It can be, as this time exists, I'm not discussing these questions. This PPT will be available in the LJRF platform, and you can also take exams in law exams. So let me conclude my review class. I hope you understand my topic, and it will be helpful for you to review the topic. Let me conclude. Thank you.
The president has some powers as per the constitution to declare some issue as a federal issue, and then they can take over. So you have the federal investigation team